of September 26, 2024. Please call roll.
John Zilich, the second.
Present.
Warren Jensen.
Here.
I note Terry Smith as absent. Natalie Sheard.
Here.
Glenna Rossi.
Here.
Sortow.
Yeah.
Chairperson Jenkins.
Here.
Thank you.
Please stand and join me in the Pledge of Allegiance. Pledge.
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Is there anybody here that wishes to speak about a non-agenda item today?
I have no submitted blue speaker cards for public comment.
Thank you. We will move to item number 1, please. Staff report.
We're pulling that up right now. There we. Is it not going to show?
It's just gonna.
Oh, okay. All right. Good evening, commissioners and Chair Jenkins. Thank you guys so much for being here tonight. First on the agenda, we have a tentative parcel map, TPM 2401, and it is for the Oroville Car Wash. The next slide. Sorry, for some reason our PowerPoint wasn't working properly, so bear with us, please. So the Oroville Car Wash is located on Feather River Boulevard, just a little bit south of the intersection of Feather River and Oro Dam. Currently, it is one lot, and it looks kind of like a C that is right behind the coffee shop. And this is going to propose to split them into two. So right now, the car wash has two different car wash businesses. One is the drive-through, and then one on the northern side is the self-serve. And so what this is proposed to do is to separate those into two different parcels. Next slide, please. Thank you. And so, as I just said, two different parcels. I tried to make it a little bit easier to see visually. And so the north will be the self-serve car wash, and the south is the drive-through car wash. There was some discussion that had occurred between engineering and planning and the applicant, and that was around easements. There was a little bit of trouble finding some of the access easements, some of the utility easements, but engineering has been working with the applicant to make sure that all of those are located and accounted for, and there is a condition that the final map has to show all the easements on it. And so planning was satisfied with that requirement, and we moved it forward to your guys' review today. Next slide, please. And so as conditioned, and with that condition that the easements are shown on the final map, it does meet both Title 17 and Title 16 of the Oroville Municipal Code. Next slide, please. And so our recommended motion is that we do the public hearing, we adopt the notice of exemption. This is qualifies as an exemption because it's a minor land division, and we recommend you approve the map as well as the resolution associated with it. I do have the applicant here today, and we also have engineering here today if you guys have any questions. And that concludes my presentation.
Thank you. Would the applicant like to speak? Okay. We will open public comment. Is there anybody here with blue card?
I have none submitted on this item, sir.
We will close public comment and limit discussion between staff and commission. Anybody have any questions, comments?
Doesn't seem to be a problem.
We're open for a motion.
I make a motion.
What, just does it have to be added for the easements to be shown, or was that part of it?
Required.
Oops, I turned myself off. That is already on there. It's condition number 4.
Okay, thank you. Go ahead, sorry.
I make a motion that we approve item 1 as it is on the agenda.
I second the motion.
Thank you. Please call roll.
Oh, I don't know why you guys are marked absent, but go ahead and mark it.
Oh,
and
can
I will
you?
fix that for you.
Do you have to hit it again to get it to?
Showing is absent.
Well, I will verbally call this one. Commissioner Zilich,
Yes.
Commissioner Jensen,
Yes.
Commissioner Sheard,
Yes.
Commissioner Rossi. Yes. Commissioner Tao. Yes. Chairperson Jenkins.
Yes,
Thank you. Motion passes unanimously.
thank you.
Thank you.
We will move to, oh, well, wait a minute. And we will move to item 2 for a staff report, please.
Just loading it.
It's loading, guys. Thank you. Okay, so well, it didn't show up very well, did it? Gold Creek Commons is a subdivision and development that the city has been looking forward to for quite a long time now, and it's a very exciting time in our history to be a part of this. And so today we're going to do the first step, which is to do the subdivision itself. What I have here in front of you is an artistic rendering of what those buildings will look like, as that bridge is supposed to go over the storm drain that is, runs adjacent to Oro Dam. Okay, so yep, here is again another architectural rendering of it. We are looking at a total of 11 parcels. With that, I do want to take a moment to make a quick correction. When I published the staff report online, I apologize, but I had the wrong subdivision in there. It showed 12 parcels, one of those parcels being parcel B, which would have held a monument sign. That would have resulted in an off-premise sign, which would have made it a use permit, added a whole bunch of layers, and so the applicant agreed to remove that. So I do have the correct one. It is on the dais with you guys right there. It's the largest piece of paper. It was also emailed to you, and then flip to right there. So this is what it looks like, right? This is the correct version of it, and if you look at the bottom corner, there is no parcel B anymore. And one more. Thank you. And then again, I tried to make it look a little bit more easier to visually see. So it is proposed to have 9 condominium style parcels, and those will each have a different commercial / residential building. The guy at the very, very top, which is parcel 10, he's in orange. That is going to be a battery storage. And then the outline in blue is parcel A, which is the remainder, and that will include the parking, the public space, and all the access and the easements. Next slide, please. Here is a conceptual site plan of what that would look like. The purple being all the individual parcels, and then the green is where the parking would be on parcel A. And so, go ahead and go to the next. So again, as conditioned, staff has worked with both the applicant and the engineering division, and this subdivision does adhere to both Title 17, which is our zoning, and Title 16, which is our subdivision ordinance. There is, because this is a subdivision, an engineering report included in the packet. And with that, our recommended motions are to hold a public hearing. This has a CEQA notice of exemption. It's a little bit different than the previous one. This is done under AB 430, which was in response to the campfire, and it allows for a more streamlining process of some subdivisions. Again, there are findings and proposed conditions, and the resolution that accompanies it. Before we make a motion, though, Wes is going to talk about some of the conditions. There are a few changes we are proposing, and he wants to discuss the CC&Rs with you guys. So at this point, I will turn it over to Wes.
Sure. Thank you. I'd like to call your attention to proposed condition number 5. That's on page 19 of your packet. That says that all buildings shall look similar appearance and design. What is not mentioned in that condition and what we propose to be added to that condition is a reference to the codes, covenants, and restrictions that were part of the application package in draft form in 2022, a copy of which has been put on your chairs there. And it's way too long for you to read, so I'd like to go over it just a little bit to show you what's in it. Article 4 talks about design. So there will be a consistent design of all buildings, both the residential and the commercial buildings, so that it will look appropriate and cohesive. That is discussed in Article 4. Article 5 discusses uses and prohibited uses in this project. Indecent or pornographic uses, massages will not be allowed. Head shop store will not be allowed. Gun ranges will not be allowed. Cemetery, mortuary, funeral parlor, commercial laundry or dry cleaning, any other offensive or obnoxious, any other activity which will emit offensive or obnoxious fumes or odors. Warehouses or big boxes would not be allowed in this location. No manufacturing, assembly, or agriculture or mining. No flea markets or fire sale stores, antique shops. No vehicle sales. No repair services, vehicle repair services. Those are banned in MXC anyway. Car wash, tire, battery stores, or churches, synagogues, other houses of worship. Those will be not allowed in this development. And so I just wanted to point those things out. In addition, Article 7 talks about assessments and shared expenses and how maintenance and everything else is to be taken care of. I do have a question for the applicant. It appears to focus primarily on the commercial components of this and doesn't seem to mention the residential components of this. So I wanted to make sure that was covered in the CC&Rs, and if not, that you would be willing to make sure that is adequately covered.
I got it. You're good. Yep.
Sorry.
My name is Brent Moore. I work for Universal Engineering Sciences, which is the consulting firm that was hired by RCM to put this project together, and we're the company that also helped to put together the covenants, conditions, and restrictions. It's our intentions in that CC&R that basically we have two different organizations. One organization is basically the ground floor, and they're helping to promote and manage and take care of all the retail space and make sure that they do it in a uniformed and in a cooperative manner so that one business doesn't impact another business, and then also that as they go through the year that they create events and activities that attract people to bless those businesses with patronage. So for example, maybe at Christmas time, they'll help to, as a business organization in those CC&Rs, they would put together, say, a Christmas display to attract people to come and enjoy and spend some time in that commercial area. Then we have the CC&Rs and the Homeowners Association, which is kind of separate for the residential areas. And then it functions the same way, where there'll be, you'll have a homeowners association dues. Those dues pay for, basic outside upkeep of the townhomes, etc. So if we didn't make that clear, we'll modify it to make it really clear that there's basically two separate boards that work with each other. There's a board that works on behalf of the residents and owners, and then there's another board that is concerned about the retail space and how to keep it occupied, and what do we do when one goes empty, and how do we all coordinate so that we can create a sense of place and attract business for all the retail tenants that are in those bottom floors. So that's the intentions of the CCNRs.
The definitions do mention residential condominium. Just wanted to make sure that it was adequately covered in this, so we can review that and
Yeah, and if we
make
need to
sure.
strengthen it up, we're happy to make it stronger and more clarified so that there's no ambiguities in it.
Thank you. So we are proposing a wording change to condition number 5. And as soon as I can find it again,
19.
page 19.
19, yeah.
Okay, thank you. So that the wording would now state, all buildings shall look similar in appearance and design and be constructed, operated, and maintained in accordance with the covenants, conditions, and restrictions, a draft of which is part of this application package. And that will cover design and maintenance and all the things that Brent just talked about. I'm sorry. Oh, you want me to talk about that one? All right. There's also a change to general condition number 1, which is on page 20, which basically misstated the Subdivision Map Act. The final parcel map must be submitted for recordation within 36 months, not 24 months of approval here. And extensions for an additional period of time not to exceed an additional 2 years or 24 months. So that accurately states what's in our code right now.
One extension?
It says extensions not to exceed 24 months. So the way I read our code is it could be one extension for a year and then another one for a year, or it can be a single extension for 2 years.
I see new condition 12 also.
Oh, this.
All right, so in the last day or so, there has been discussions between PCP, which is the a neighboring property, and the applicant and staff regarding any potential mitigation that might be necessary if PCP were to have noise or odors from their property that they would be protected because they are a pre-existing use. That is a proposed condition number 12 that is on your paperwork there. It says draft on it. That was not written by staff. That was written by PCP's attorney, who is here today to discuss it. My understanding is that the applicant and PCP have not reached agreement on this yet, and so we are asking that there be a discussion today revolving around this proposed condition. And if it is adopted, it would be condition number 12 under project specific conditions, not under general conditions. And that concludes my report. Thank you.
Thank you. Would the project applicant like to speak?
We took a look at what was proposed to us, and we've sat down several times with Pacific Coast producers, had several meetings, took in their advice or their requests. RCM removed a whole building because they were concerned that their activities is non-conducive to the mixed-use corridor zone, which says that the land uses and the activities shall be attractive development, commercial and residential. They know that their activities are not attractive. They know that their activities are a nuisance. They know that their activities cause pain and suffering to surrounding neighbors who continually complain about the dust and the noise and the smell and the odors and the stuff that's just not pleasant. It's not non-attractive. They are a non-conforming land use within your code. You did a general plan update and you made it mixed use, general plan land use designation. You applied a zone to it called mixed use corridor. And you have goals and policies with that general plan. And you have goals and objectives in that zoning code. What this attorney is asking is to set aside your police powers, set aside the desires and the ambitions of the community when they adopted that general plan, conflict with it, and then do private legislation on the side without CEQA, without public participation, without any input from the community about what should happen here, and then circumvent your police powers by inserting an easement which removes all of our rights and privileges under that zoning code. We think it's kind of crazy that we would want to give up the police power protections that the city has provided us, that gives us the opportunity to plan a community like that. What they're asking us to do is, you tolerate our industrial agricultural activity next door, and you tolerate no matter how we do that stewardship. If we leave a bunch of tomato skins sitting outside, rotten and smelling and creating bacteria and attracting flies, then you have no right to come and tell us to manage and operate any other way, because you allowed us to put a covenant and an easement on your land and circumvent that zoning code, circumvent the will and the desire and the future of what the city of Oroville planned for. I think it's almost offensive that they requested this of us, particularly after we gave up almost $6 million worth of profit in housing. We took out a whole bank of buildings because they said we don't want those people looking over our shoulders. In addition to that, they're not even our neighbors. The city of Oroville is our neighbor. There's about a 200-foot lot between us and them that's owned by the city, zoned as public, quasi-public, and the city chose on that zone, that lot, to lease it to them. So we have a buffer there. We have the city who owns the land, and it's their stewardship of that land. We don't conflict with that at all. And then they're 200 feet away from that. Well, then to accommodate them and try to be good neighbors, we took out a whole bank of buildings, as you can see now. And that sets back the housing we have even further. We also put in landscaping plans with tall trees so that even the people who are further away will be seeing trees. In addition to that, we know that they have some obnoxious activities over there. And those trees, though, will help us. We won't see it. If there are odors, the trees help to diffuse those odors. If there is dust, it'll help to diffuse that dust. So we're doing everything we possibly can to mitigate against a neighbor who's a non-conforming use, who hasn't gotten the vision of the city. The city said to them years ago, we're planning this for mixed use. We want commercial. We want residential. Can you see that vision that we have? And they sat there and they've done nothing to implement that vision. And now they're even coming in here today and they're saying to you, you can't have your vision because my land use and stewardship has priority over everybody in this city who adopted that general plan. Well, I say to you, I hope You don't accept that. I hope that you embrace the general plan. I also think that legally, you can't circumvent your own code. You shouldn't be able to vote to add this as a condition in violation of the goals, policies, and objectives of your general plan, and in violations of what that code tells you to do. If you do that, we got more legal problems. So I'm asking you, support your own codes, follow the police powers you've been granted, and obey the law, and say, hey, we got to reject this request. It's not in conformance with our general plan. It's not in conformance with our code. And by the way, you're the same general plan. You're the same zoning code. You're a non-conforming use. And this is the way our zoning administrator administers non-conforming use. We don't try to coddle you and keep you going. We grandfathered you in because that's required by our Constitution. When we change the law, we have to grandfather you in. And we are tolerating you. And we have made accommodations for you to continue to tolerate you. But you, in the interest of the public and our community, PCP should also start a plan of transitioning out, not circumventing the police powers of the city and trying to undo our general plan and undo appropriate development like this in your downtown. So I'd ask that you reject this request and you please give us support, approve our tentative map, and let us move forward with the development that is planned for in the general plan and set aside within that zoning code that we have. Thank you.
Thank you. Would PCP like to speak? Is it on?
Great. Thank you very much. My name is David Temblador. I'm with Harrison, Temblador, Hungerford, and Guernsey. And it's my privilege and pleasure to represent Pacific Coast Producers before you this evening. Let me first start off by saying Pacific Coast Producers has been a longstanding member of this community. The facility that's in question here that Mr. Moore just spoke about has been there for 40 years. During peak harvest season, it employs roughly 1,000 people as it brings harvest, and it does not produce tomatoes. It actually handles peaches and does fruit cups. Let me kind of with that back, let me start off by saying this. If what we were asking was as dramatic and life-altering as Mr. Moore has suggested, I probably would vote against this condition as well. I will tell you that is not what we were asking. What we're asking for is quite modest. And that is merely a recognition that PCP is an existing operation in this community, that it's been there for a very long time, and that during the course of their normal business, they would have potentially noise, odors, traffic, things that are incidental to their existing use and have been incidental to their use for the last 40 years. Importantly, what we are not asking is for this commission or this city to circumvent its zoning code or its development title or any of its non-conforming use regulations as they relate to public nuisances, which cannot be protected by anything under the law. If a nuisance is a nuisance and it's a public nuisance, this commission, the city council, this city has a right and indeed an obligation to stop those public nuisances. PCP, to my knowledge, has never been identified as a public nuisance within this city, and they never intend to be a public nuisance. They are merely asking for, by virtue of this condition, an acknowledgement that their operations exist and have existed for a very long time. I do want to touch briefly on the CC&Rs. You heard your principal planner mention CC&Rs. We have not seen those CC&Rs either. I will tell you that Mr. Moore is correct. We did have some, I thought, very productive conversations with his client back in 2022. We talked about PCP's operations. We talked about our concerns, or their concerns as an operator vis-a-vis their project. And those discussions ultimately manifested into what you see before you today. I will say, just as an aside, that they had represented at that time that the residents along that panhandle would actually be a hotel. Not condos, home ownership. as you might imagine, a transient occupancy is somewhat different than people's homes where they live. And so, we were concerned about that. We thought that was the direction they were going. At that time, however, I think it's important that I note that the CCNRs that have been mentioned to you were represented to include a disclosure statement that Mr. Moore had actually provided my client back in 2022 that had, and I won't read the whole thing, but I'll just say, had amongst its provisions a statement to the effect that the city of Oroville permits the operation of Pacific Coast Producers agricultural processing facilities on neighboring properties to the Gold Creek Commons in accordance with Title 17, Chapter 17.616, Agricultural Uses. Moreover, they at the time had agreed that they would include a disclosure that said that PCP's operations may at times be subject to inconvenience or discomfort arising from that operation, including without limitation, noise, odor, fumes, dust, smoke, insects, etc. When we were speaking with them back in 2022, they didn't say we were an abomination to this city. They said to the contrary. They said, hey, we recognize you're there, and we want to be good neighbors. And we took them at face value. What we were proposing is simply to document for this city and for future folks that might live in that property that we want to be good neighbors and we want to work together. We are not asking you to circumvent your zoning code. We're not asking you to get rid of your public nuisance requirements related to nonconforming uses. We're simply asking that a condition be added that requires this project to acknowledge PCP's existence. That's all. With that, I'd happy to entertain any questions, and I appreciate your consideration this evening. Thank you very much.
Thank you. And your Wes, should we not even discuss this and not consult the city attorney? I mean, is there any trouble?
Let me offer some perspective, I guess. This is a decision that will be up to the Planning Commission, whether you want to incorporate this condition or a modified condition or to wait for ruling on the city attorney. So this will be up to the Planning Commission. What I will say is that Mr. Moore is correct in that the PCP plant was rezoned as MXC at some point in 2015, 2009, and 2015 when the general plan was enacted. It is therefore a non-conforming use. However, it is a very, very important employer in our city, and we would not be at all interested in having them leave or seek alternative locations at this time. I would actually recommend moving to rezone the property appropriately if that was the case. This is a very important employer for the city. And I'm not saying that for myself. This is something that is discussed quite a bit amongst the staff. There are options. This condition, and I'm hoping that the two parties here comment on this, but there are options. One is that it could be, as suggested here, that it shall be recorded as a covenant, or it could be notice or disclosure statement. As you know, if you buy property or are near an airport, there's always a disclosure that says you are within 1 mile or 2 miles of an airport, and there will therefore be noise and odors and other kinds of activity that might be nuisance oriented. The Alquist-Priolo Act requires notification if you're in an earthquake zone, so that those are part of the documentation that when you purchase a property, these are official notices, and therefore new property owners are legally made aware of this. So those I think, are a couple of options that this Planning Commission has, and I'm hoping that you allow the two positions here to talk about those.
What? The last subdivision we approved in the airport flyover, what did we we did something like that, right?
We required that in the real estate transactional documents that a notice be included in those documents, that new owners be made aware that they are within an airport overflight zone.
Can I understand the impacts that are difficult to curtail, that a residential high-end community could not be close to it? I do know the parking is atrocious because I live down there, but the other impacts they're kind of big, and I don't really understand. I mean, I don't live close enough to hear the noise and the vibration and the dust, and I would like to have a better understanding of that.
You know, if I may, I just wanted to make sure you're comparing apples to apples. What Wes was talking about, and what you asked about in an example, was the airport. The airport's in compliance with your general plan. It's in compliance with your zoning code. So it's supposed to be there. You planned for it. You declared to the public it's going to be there. So it makes sense that you put, a statement on people who are purchasing and developing around an airport that's planned for. Don't forget this. But what you're saying to us is we have a non-conforming land use. You planned it out. You planned it out so it's going to be obsolete. And then you say to us, we want you to give up some of your rights under the zoning code that we planned for you because we really didn't mean it. That's crazy. And if you're that wishy-washy with your general plan administration and your zoning code administration, nobody can trust you. So we won't want to develop here. So you have to stick to your guns about what you're doing. When you, in 2009, and then again in 2015, rezoned them to mixed use, and you changed the general plan designation of mixed use, you set the fate. And that's our problem is, wait a minute, you're a non-conforming use and you're asking us that when you create these nuisance, you want us to just keep our mouth shut? When the city's told you we don't really want you there. Now, I agree, if you've changed your mind, then as Wes is saying, you need to go back and you need to do a general plan amendment. You need to go back and you need to change that zone so they're no longer non-conforming. And you need to adopt a CEQA document. And because of the conflicts between that land use and these other surrounding land use, it's probably an EIR. Because you're going to have to show overriding considerations. And you're going to have to declare to the public, we know it's a bummer. We know you're going to be impacted by noise, dust, odors, other pollution. For a while, it's going to be things like idling diesel trucks. 5-6 years from now, they're outlawed. So at least that'll go away because all trucks have to be electrified. But still, you're going to have these impacts and these land use conflicts that can't be overcome. It's okay for you to adopt that. You got that right. But you have to declare it to your public and you have to say to them, no, we made a mistake. We really want PCP to be here. So we're going to re-legislate and put it on the map. And if that happened, then we'd be more like, okay, I guess we do need to tell our future tenants that this is the plan. But what we're going to tell our tenant right now is the plan is they're exactly like you. And they're supposed to do exactly what we're doing. And we're supposed to create a neighborhood and a community with a sense of place that we all enjoy to live and that we're not aggravated by something that's there that's non-conforming. So you gotta think about that. It's not apple to apple. Airport is a legitimate land use planned for in your general plan. PCP is not a legitimate land use. You made it obsolete. It's non-conforming. And if you go look at the government code, which oversees your municipal code, it talks about non-conforming uses and what your obligation is under the law. You can't aid and abet it. See, you know, like if it burns down, you're not allowed to let them go back and rebuild. It's gone. So by you saying to us now, well, let's put together some extra policies that you're going to adopt outside the legislative process because, you know, we couldn't have gotten this through legislatively because our representatives on our city council adopted a general plan that said no. Our representatives on the city council adopted a city code that said no. And now you, if you accept this proposal, you're circumventing your
helping
city
anyone?
council.
It's feeling like you're talking down to us now. So if you're not answering questions,
Well, I just want you
you're repeating yourself,
I want you to
and
understand that.
you're
Okay.
accusing us.
Okay, I understand that.
I have a question.
Yeah.
What are we at? What is this for? Why are we asked?
Yeah.
Why are we asked this? What's the beef with PCP
Exactly.
and you guys? They're there. Okay, you want to be there.
Yeah.
Okay.
We want you there.
You have to.
Because,
In real estate, you have to disclose everything.
Yeah.
You know that,
yeah.
right?
Yeah.
So what are they asking you to do,
To accept, yeah.
and what are you asking them to do?
We're not asking them to do anything.
So then, what is this for?
We're saying,
Mr. Attorney, what is this for?
yeah.
So we're getting off in the weeds on.
Well, it's
everything here.
it's so that when people move in here and they find it offensive what their neighbor's doing as a non-conforming use, they don't want to hear phone calls from them saying, "Hey, why are you doing this?" They don't want the property owner association to say, "Geez, we've had enough. Let's go to court and get a court order against these guys." They don't want to face that again and again and again and again and again. And it happens. You know, I have a client in Hayward. Same thing happened to them. The property next door converted to townhomes, and the townhomes kept on sending him complaints. He had a manufacturing process with cement, and it put out dust. And eventually, the lawsuits and the complaints got so bad, he finally said, "I give up," and he sold his land, and he moved his manufacturing process to another location. But that was another one of those situations where the city planned for this townhomes because they needed the housing. And they happened to put it next to this industrial site. And so it did force it out. And so the same thing could happen here where you have a non-conforming use, they're doing certain activities, and now you added 176 residences. And those 176 residents have a lot of clout. And collectively, they all say, we're all going to contribute $1,000. And now they have the ability to legally harass you with court orders and injunctions and just make doing business miserable. And that's where they're saying, wait a minute, we don't want you to ever come over here and say you don't like what we do. And we sure don't want you to have the right to go to a court and use a court as a club against us. And we're saying, well, we don't want our residents to have that binding on them. We want our residents to have the joy and the pleasure of a general plan that's being implemented and a zoning code and all the entitlements that code gives them without constraints from an agreement that was slid in as a private process, as a condition of approval outside the legislative process that circumvented those privileges we got under that mixed use corridor zone. That's it. It's just that simple.
Okay, so you're not going to stop being litigious. It's
No.
that simple, right?
Maybe
won't-
not.
That won't happen. And, you know, there's plenty of NIMBYs. There's plenty of people they don't, you know.
But if that was on there, it's real easy for me to write a demur and say, Judge, this is the agreement. Here's my demur. Please throw this complaint out. And the judge does, because he doesn't have a choice, because that is on the deed.
Well, if it's clearly PCP's doing this because they just don't want to get phone calls, or they don't want the HOA to get together, sue them, to
Yep.
put them out of business, to say you can't work.
Glenn, will you turn your mic on, please? Thank you.
I mean, conforming, non-conforming use, they're there, they've been there, right? Mm-hmm. So when people buy real estate, they buy a home to live in, they know what their surroundings are, right?
Yep.
They're aware that these guys, they cook, smoke comes out,
Yep,
trucks go by,
yep.
okay, train tracks, I don't know if those are active lines or not. They are, but, I mean, that's there. It's disclosed by the seller. When someone buys a condo, right, that these guys are here, that's what happens.
Gets a little more
Right.
complicated, though, because when you disclose it, you're going to say it's a non-conforming use. The zone is the same as this.
Why do you have to disclose to the buyer that the neighbors is a non-conforming use?
Because it matters. Non-conforming uses don't can perpetuate on and on and on. They they have a deadline where they kind of die.
clarify our existing zoning code as it relates to non-conforming uses. It is a non-conforming use, but it is allowed to exist and continue in perpetuity if it so wants to. If it expands, it requires a use permit in that case of an expansion. And if it is burned down, they can rebuild it exactly as they had it before without changes. So that's all in our code. Yeah, within 12 months, but yeah, get construction started again within 12 months. So those are in our codes. So
Yeah. So there is some ability to try to keep a non-conforming going, and that's right. But there's a lot of constraints on it, and a lot of issues that usually make non-conforming uses go away eventually.
I don't think that this commission voted for that to be a non-conforming use. The city hired a consultant. The consultant did many lots that we have rezoned, and we didn't specifically approve that to be that zone. I got here about when we were approving that, and it was like somebody took a highlighter over the city and said, this is going to be the new zone. And I don't believe every single person got a letter saying we were rezoned. There were a few businesses that came in here saying they were rezoned and didn't want it. But I'm sure the cannery, if their lawyer got it, would have came in here and argued that they didn't want to be that zone.
Well, typically when you're doing a general plan update, you have a public participation process. You typically don't send notices to every property owner in the community. You let everybody know you're doing a general plan update, and that, you know, and then
I'm just telling you how it went.
Yeah.
And you're trying to still convince us that. Do we have any more questions?
Well, again,
I know the other side would like to.
Yeah,
like to
yeah.
turn
I want to
to,
hear
so.
from
Yeah.
PCP's attorney, because you know, we're asking, we're trying to see into the future of who's going to do what and when,
Right.
and it seems like, you know,
Yeah, yeah. Is it Commissioner Arasi? Is that correct? Commissioner Arasi, you ask a very good question, and I appreciate you asking it the way you have. Let me try to do a couple things. First, let me try to take the temperature down. I candidly was coming here this evening in anticipation of saying PCP is very much support of that project, of the economic development that's going on that site. You know, we're not opposed to that happening. All they were asking for is some simple acknowledgement of their existence. So let me go back to that. So really, in principle, PCP is asking for two things. One is a disclosure that, as your principal planner has already acknowledged, would be akin to a disclosure document that would go into any real estate transaction of any future purchaser of a home within that community. That would simply say PCP exists and that they have, I wouldn't even be opposed to saying it's a non-conforming use. I don't think it's germane, but it's a non-conforming use. It does have some activities that are industrial in character that you may find uncomfortable at times. That's the first thing that we're asking for. The second thing we're asking for is what we would characterize as an easement that would be a legal document executed as between the two properties that would run with the land. So as you heard on your prior item, all easements come on the map, right? So we're asking for this question right now because this is when the city imposes easements on real property as part of their discretionary review process. So we're asking for an easement that essentially says a similar thing to the disclosure, but would be signed by PCP and by RCM Investments, the property owner right now, and that would then be recorded, and it would be, in addition to the disclosure, it would also be on title for everyone going forward.
What's the easement for?
The easements for light, odor, noise, those types of things, just acknowledging that they're there. Now, you asked a question about litigation. Litigation is going to happen. So, Mr. Moore's kind of story, his anecdote about his friend, is exactly the case. We represent industrial operators all up and down the state of California, and that is true. Lawsuits can't be stopped. But a company like PCP, who is a good operator, who is a good employer, who is a good citizen of their community, gets sued, they got to have something they can hold on to, so folks like me or others in the legal community can help defend their right to continue operating. As has already been indicated, your zoning code allows for them to continue in perpetuity as a non-conforming use. I would further submit to you that the California Supreme Court in Hanson Brothers versus the County of Nevada legally recognized vested rights, vested land use rights, like PCPs. So I hope that clarifies what we're asking for. I would close by, I'm happy to answer your questions, but I close by saying this. We did not intend for this hearing to turn into what it's turned into. I'm a lawyer trying to tell you about legal things. It's not good for my business to tell people to break the law. It's a bad deal. Not doing that. But I recognize that if there's legal questions that this city needs to answer in response to Mr. Moore's comments, we think it might be appropriate to ask your city attorney, and we'd be happy to engage in those conversations. So thank you very much. I appreciate it.
That yard, so where the building is, I don't know what's there. I mean, when I drove in there yesterday, it looked like there's a cyclone fence all along the entrance to the proposed entrance to this, correct? And just on the side of that fence, you have pallets and
Yeah.
items stored and everything, right?
Right.
It's
It's-
property where that's stored at.
So it is.
Let me, Commissioner Rossi, let me answer that question. So that area that you're seeing on your screen,
Yeah.
is a open storage yard. So equipment, as it's getting ready to be replaced in the plant operation, or it's being taken out. It's also truck storage. It's kind of incidental yard storage for the operation.
How much is that yard used?
It's used significantly.
Is that yard paved?
No, it's not. It's not paved. It's gravelled, I believe, right? It's gravelled. It is used significantly during the harvest season. So as trucks come in with fruit from the fields to be processed, they come in through that route. And that, candidly, that's part of the reason why we're here tonight, is we just want to acknowledge that that's been happening for 40 years, and we hopefully like to continue doing that. I mean, PCP would love to invest more in this property and continue to utilize it. But the reality is, kind of as you're looking on that map, yes, it's a city-owned easement that they give to PCP, but it's there. Practically, it's there. And so...
Your guys are using the city easement
yeah,
for your storage yard?
Yeah, pursuant to an agreement with the city.
And how long has that been going on, and how long is that for? Or
That lease, I believe, is good through 2025, and they have already asked to renegotiate that lease and/or to purchase that land. So the city has made no decision in that regard.
But just to kind of take it a next step further, Commissioner, the warehouse building is on PCP owned property. Yeah.
I mean-
yeah, and so there's buffer on that. I mean, there's adjacence to that.
Is the dust mainly from the gravel? What is the dust from?
I don't want to exaggerate how much dust there is. There's when you drive a truck over gravel, it's going to kick
So
up a
it's
little
the
dust.
gravel.
Yeah.
It's just the word, it's nebulous to me. Reasonable impacts is extremely subject to interpretation.
Yeah.
And then, noise can be reasonable and it can be terrifying. And vibration and dust
Sure.
and all of that. So
Sure.
this is too nebulous
Sure.
for me.
We would, and that's a fair question. So we proposed it as a condition that would be then subsequently drafting an easement after the fact, so that the parties could resolve some of those kind of more nebulous pieces. What I would say, if it gives the commission comfort, we would certainly agree to add to that condition those items and to say, provided that they do not violate the city's nuisance ordinances. which established thresholds for
That's
nuisances.
what I was
and all.
thinking.
Yeah,
There's
and
no threshold.
super comfortable with doing that.
But has the company, can they not make any more efforts to try to mitigate dust and noise?
Certainly.
Like knowing that this is such a wonderful development that we all want. I know we all want both of this to work.
Yeah, certainly. And let me back up for half a second, Commissioner Sherrod. Is it shared?
Shared.
Shared. Commissioner Sheard, let me back up for a second. So we initiated these conversations with RCM Investments back in 2022. And we had a sit-down meeting. City staff joined that meeting, and we talked candidly about all of the things that you're asking. And we thought that we'd come to a fairly good resolution. And Mr. Moore and his client said, hey, we're happy to make some adjustments to it. In the context of that conversation, he said, hey, we're willing to put a disclosure in our CC&Rs acknowledging PCP's there, and it might have odor, noise, et cetera, the things that I read when I was first up here. And we said, hey, that's great. Would you also be willing to consider an easement, the easement that we're asking for right now? The world went quiet for 18 months until PCP received a notice from the city that this hearing was occurring tonight. I personally contacted Mr. Moore last week, said, hey, understand this is coming in. Thanks we just found out about it. We might have some questions. Can we understand a little bit better? We followed up with your staff. We got a copy of what you're looking at right now in terms of a staff report. And we said, oh, hey, we might have a couple concerns. Let's see if we can discuss the easement that we had previously discussed back in 2022. And I reached out to Mr. Moore on Tuesday. We talked on Wednesday. And we gave him what you have in front of you right now. So we are trying to engage in this as soon as we knew that there was something to engage in. So this notion that we're coming at the 11th hour or things like that's just simply not true. And this is not something that's in the dark of night. This is a public hearing. We've presented this to you in a public hearing so that as members of the public, as the commission of the city of Oroville, you can consider it publicly. So to your initial question, we would be happy to add that restriction or work with staff to come up with something that's amenable to all sides, including the city. We're just simply asking for consideration of the existing operations.
If I may, I just want to throw this out there. Yeah. If the odor levels, the noise levels, and so on and so forth were kept within city standards, would that be amicable to continue forward with the development?
Well, there are some things that are not city standards. For example, the Butte County Air Pollution Control District has air quality regulations regarding odor.
Excuse me, sir.
Dust.
If you're going to address the commission, can you please come to the lectern? Thank you.
So the Butte County Air Pollution Control District regulates dust, odor, and they have rules and regulations for that. And and that's what's kind of bothering me is like PCP is coming to us and saying, yeah, but we might not follow those laws.
Right, but that's what I'm asking.
Yeah.
But if they followed all the laws, the city has noise ordinances that on the line in an industrial zone or a commercial zone, when you get on that property line, the decibel levels can only be a certain limit. When you exceed that, you become a nuisance and the police are going to show up.
And I understand that. What I'm asking is if it was added to, it was added in there that it was going to be kept the decibel level, the certain working hours of the night. There's all those ordinances that are in there, and if those were all put in this, we don't mind putting in the CC&Rs that, oh, by the way, next door is Pacific Coast Producers, and this is what they do. But we also want our residents and the commercial owners to know this is what they do, and this is what the regulations are for this person's stewardship. And so if they exceed this noise at this property line, they're in violation and you need to call the police. If they are producing dust with their trucks and it's this particulate matter that's coming out, they're in violation of the Air Pollution Control District. You need to call the Butte County Air Pollution Control District and get an enforcement officer out. If they're producing odors, see, I think it's already regulated. It's already there. So we don't need an onerous easement laid on top of us that circumvents all those standards of regulations and standards of conduct.
And so I just think it's one of those issues where, yeah, we could put in the CC&Rs an extra paragraph that says there is a non-conforming use next door. It's Pacific Coast Producers, and Pacific Coast Producer does these activities, which results in these kind of things. And then we put another paragraph in and say, in accordance to this ordinance, this rule and regulation, and this and this and this, these are the exceedance levels they cannot exceed. So if you find they do that, you got your table in your CC&Rs so that you're educated as a property owner. So if you're seeing a bunch of plume of dust and you look at your table and you go, man, that's an exceedance, go ahead and make your phone call. And then if you start finding that the local government won't enforce the law, because sometimes that happens, well, then you're going to have to get together as a property owner association, go down to the court and file for an injunctive relief against the official who won't enforce the law. But but at least then they're educated. They know that.
And that's what I'm asking. That's
Yeah.
what I'm asking is are you wanting them to just go away, or are you wanting them to work within the confines of the nuisance ordinance?
We want them to just stay within the confine of the nuisance ordinance. And we also think, when I read the mixed use code, it says in there that you can issue a use permit for the kind of activities that they're doing. So instead of making them a non-conforming use, I think the easy way to handle it too is, instead of doing a general plan amendment, which is hard, is maybe just go give them a use permit. Now, if you give them a use permit, you set all the standards in that use permit that they have to follow to ensure that they don't mess with your neighbors.
Right.
And then that way you're governing between the two entities so that they can coexist and not be paranoid and worried about, geez, what if they file 100 lawsuits against us and pretty soon we just can't afford that overhead cost.
See, what I'm trying to do is I'm trying to narrow this down to a fine point, because
Yeah.
there's a whole lot of generalizations here. I'm trying to narrow it down to a fine point. So what I'm saying is, currently, right now, is PCP doing something that's detrimental to the development that you're building?
No.
At this moment?
No.
So if
They
they continued,
exceeded- I'm sorry.
I'm just saying, if they continued moving forward at what they're currently performing there as far as work, then there's no detrimental effect to what you're building, to the development.
I don't think so. I've never seen anything.
That's all I'm asking, is just your opinion. So stepping that forward, what you're asking then is that this proposed condition of approval not give them carte blanche to increase the level. You don't want them to drop 1,000 tons of rotten peach pits.
That's right.
There on the fence line. You want something in there that conforms them to what they're doing right now as the limit for the decibels, the odors, the dust, and such. So you're okay with what they're doing right now. You just don't want them to have carte blanche to be able to increase their activity to become a detriment to the new development.
Exactly. And we want the residents to be able to know that there are rules and regulations, and you have a right to invoke those rules and regulations. And you have an expectation that the government officials will enforce those rules and regulations.
What I'm trying to do is de-escalate from the fact that we went, because I'm sure right now PCP is kind of on the fence here, thinking that they're being attacked for what they're currently doing, not just what they might do in the future. And I'm trying to de-escalate that a little bit to show them that you're okay. Right now, the development will move forward with the current level of use of that property. What you're asking is that the use doesn't increase exponentially and become out of hand.
Exactly. And quite frankly, we thought we had everything worked out with those guys. That's why we removed a bunch of buildings. That's why we modified our plan. And we thought everything was copacetic. So it was a little bit of a surprise. And it is, he called me last week, but he didn't say last week, hey, by the way, I'm going to throw a boomerang at you. Right. And then I got the boomerang yesterday, and I looked at it and thought, you got to be kidding me.
Well,
all right. In the interest of time, could I go ahead and ask a couple questions of the attorney, if you don't mind? I'm sorry.
No, go ahead.
Thank you, Commissioner.
So right now, this is a carte blanche condition that you've put on here. You can basically do anything you want to do with the property, and I think his concern is valid to a certain point, because they don't want you to put 1,000 tons of peach pits right on the property line. So could this be rewritten and resubmitted from you to Mr. Moore as the current use of the property and how the property is currently being used with decibel ratings and so on and so forth, that you'd be amicable to continuing at the current level and not increasing, and then that could be part of the disclosure to the future property owners?
Yeah. Two comments to that, Commissioner. One, yes, happy to have dialogue conversations with Mr. Moore. The purpose of the condition was to do that dialogue in the context of city staff as well. So questions like what appropriate thresholds, be they air pollution control district thresholds or city thresholds, would appropriately be applied. So the answer is yes, we'd be happy to have that conversation. Secondarily, there's no version of the world where PCP is ever going to violate any of the applicable standards. So I realize I'm kind of leaning in a little bit, but I just want to make sure that's clear on the record. So,
Right.
Okay. Have you operated outside of your normal decibel level?
not that I'm aware of, Commissioner.
Has there been any complaints from to the city in the last year or so of PCP dropping 100 pounds of peach pits and operating with dust and smoke and excessive noise?
There have been complaints, but they relate to parking only, not
Kind of-
not
what
to
kind of
noise
parking?
or the adequacy of parking. And we have been working. We have been working
employees.
for the employees and for residents on the street and such. So we have a permit process in place.
Yeah, permit
And
process.
we've been working with PCP, and they've actually purchased additional land recently in order to alleviate that problem.
And you
But
have.
we have not had any other complaints in
Can
any
you
other
have some
area.
of PCP parking in that easement?
I'll say that the PCP actually approached us to put the parking restrictions in place. It was their initiative to have a parking permit program so that their staff member or their seasonal employees would keep PCP being a good neighbor to to the neighborhoods.
Right, so I mean, is there any room for your employees to park in this easement if there's the need for that?
Yeah, I think, well, two comments. One is, as ours have been staff just mentioned, PCP's actively engaged in this conversation and indeed initiated it because they want to try to resolve it. So that's just kind of PCP's kind of culture, is to try to get ahead of issues. Yeah. The specifics of how to resolve that, I don't know that I'm their attorney, so sure. I'm not appropriately kind of here to be able to answer that question. Right. Nor is Mr. Myers. He's not that spot in the. But the kind of the answer to your question is certainly, I think PCP is open to whatever discussions are available to make sure they're good neighbors. How they kind of work themselves out on an actual on the ground basis. I think that there's probably people that are in the room besides me that are smarter to be able to answer that.
The commissioner said about bringing the noise level down. Mm-hmm. I mean, I think disclosing this to homeowners vis-a-vis, it's a non-conforming use. If you don't like the dust, call. So you got a bunch of little Dutchy police running around trying to call the police and everything, and you want to stop that. I understand that.
Yeah.
But you don't want to have a bunch of hall monitors either. Mm-hmm. But you also, I've never seen it's a cannery. You're going to have noise. You're going to have some odor, but I haven't noticed anything personally out of the ordinary.
I appreciate that.
I mean, I don't know if we, even if you got everything you wanted, you're still going to get sued if it's approached, that way, in my opinion. So, I mean, this was something that I didn't see this week in my packet. Was this in our
No, it
packet?
didn't come till today.
And the CCNRs, did they come?
We did not receive the proposed condition until today. The CCNRs were not in the packet, and I will take responsibility for that. My understanding was that had already been discussed with you guys previously.
A couple years ago.
Okay.
I do remember that.
So I apologize for that.
I mean, so for me, it's up to the chair, but I don't know if we're in a position without reviewing and knowing exactly what's going to appease both of the. I mean, I like the project. I'm for the project. By all means, I'm for the project.
Love the project.
But I don't know.
Wes, would we be able to move this along with item 12 or condition 12 being staff and a mutual agreement between the two parties?
That is an option up to the planning commission to decide if you would like to.
It sounds like everybody's pretty good on
Delegate that
everything
to
except for
staff.
item
Well,
12. Or
Can I ask one more question here? I'm not a property lawyer, so what is the difference between having an easement versus an agreement amongst the purchasers of the property and the development? Why one over the other?
Sure.
Because that sounds like that's the main contention here.
Sure. It's in its simplest form. It's an additional kind of maybe a step up of protection. So with a disclosure kind of being at the bottom rung, an easement kind of being another rung up legally. So if in a circumstance, if a property owner there came in and said, "Hey, we're going to file a lawsuit against you because of your noise," if we would come back and say, "Well, there's an easement that says that everybody recognizes that noise," and they would, if we are violating some standard,
Right.
Commissioner, to your point, we would lose that argument. But if we are in accordance with all of our standards, that provides us an additional protection for a court to say, actually, Pacific Coast Producers is complying with the law and their easement. So it's think of it as just as kind of a rung up of protection. And that's all we're asking. So, Chair Jenkins, unless you have other questions,
Yeah, no,
I don't want
just feel
to.
like
I
we're
want
trying
to be super respectful
I
of
feel
your
like
time.
this is a big thing, and we're trying to rush this in.
Yeah, I'm not
Yeah,
doing
that's
that.
the way
We
I
need more
feel.
time.
And
I don't know
I feel
what-
like if you guys could work with staff for a mutual agreement, my opinion,
Yeah, no, I agree. I think condition 12 needs to have some language in it specifically holding what PCP's responsibility is and making you comfortable as far as what their limits are to be able to be your neighbor.
Yeah. And we would be amenable to those conversations. Again, PCP is not opposed to this project. They just want to make sure that there's a recognition these two things can live together very, very well for a very long time. So thank you very much. I appreciate it. Thank you.
Just saying, it kind of sounds like it can live together because we already have a nuisance ordinance. We already have things in
Yeah, we
place that
have
should
the regu-
make this live together.
Have the regulatory
So
structure already.
we want,
right?
yeah, anyway.
So,
If there is such a motion to delegate to staff to work it out amongst all the parties, does the planning commission want to see that again?
Yes.
Or to have it reported, or, because that will decide whether you take action on the project or table it pending report back. So that's an option you have.
we just need to straw poll on that, or?
Wait, what are you saying? We can't?
You can
Approve
take,
what's here?
You can take action on the project
Okay.
with the proviso that staff works something out and we report back to you. Or you can still maintain the decision-making authority on condition 12 for the next meeting. So those are options.
Well, I think our issue with condition 12 is basically, we just want to make sure it conforms to what's already in place as far as nuisance ordinances. And I think basically it's the agreement between the two parties, in my opinion.
Agreement.
I think, yeah, if they can work it out with staff to their mutual agreement, then I'm fine with it. You know, as long as they can live together.
So a motion was there something else extra added onto that?
There were two conditions that are being edited. So the motion, she's putting the motion up for us. But it would be you could, instead of adopting the resolution as is, you could adopt it with the discussed amendments to the, potentially adding one condition with staff working with the applicant and PCP to come into a resolution, and then adding that a bit more detail to condition number 5, and then the other condition, which I
Was the
apologize.
timeframe, yeah.
Yeah, the
now,
timeframe one.
The instruction for staff to work with the applicant and Pacific Coast Producers, would that then be a condition of a project-specific condition of approval? Would that then be 12?
Yeah, it would be project-specific number 12.
Got it.
So you could approve it with that caveat.
Because I don't approve project, number 12.
Yeah, so you wouldn't
okay.
be doing it with 12, just
Wouldn't
with
be,
a,
it wouldn't be this, it would be, it would be a proviso that the staff
Yeah,
would work
a
with the
mutually
applicant and
agreed
Pacific Coast
upon
producers to
condition.
come up with a mutually agreeable
Something to go right.
agreement, I guess, is
Okay.
the term for that.
I'm good with that.
Okay.
if that was acceptable to the applicants and, you know, PCP.
Yes.
Okay.
So I will schedule some meetings.
Well, may I so move as as specified by Christina? That we move to approve with the with general condition 1 amended with the correct time frame, the addition of item 12 under the project specific conditions for staff to work with the applicant and Pacific Coast producers, and that and the amendment to number project-specific condition 5 that adds that the appearance is in accordance with the CCNRs.
I second.
Please, I guess, call roll.
Commissioner Zilich,
Yes?
Commissioner Jensen,
Yes.
Commissioner Sheard,
Yes.
Commissioner Rossi,
Yes.
Commissioner Tao. Chair Jenkins.
Yes.
Motion passes unanimously.
Thank you guys very much.
Very much. Yeah, thank you.
Wyatt, did you want me to present the next one?
What's that?
Did you want me to present the next item?
We did.
Sure, if you
You
would.
said yes.
Oh, we didn't have to push the button?
No, she just said yes.
Oh. Yeah, because
The button's not
our
working.
buttons don't work over here.
I finally do have a button. I do.
I don't have one.
You-
Oh, well,
no,
maybe
now
I
you
do.
have a button.
I just had to touch it, maybe.
All right, good evening, Commissioners. This item before you is the selection of a vice chairperson for the Orville Planning Commission. As you may remember, we did discuss the selection of a vice chairperson. However, that was not agendized on our last meeting, so this is a formality. It needs to come back as an agendized item. If you will recall, we did appoint Chairperson Jenkins as the chair, and then we did have a discussion in which Commissioner Sheard was nominated as the vice chairperson. I just wanted to refresh all of you on that, and if that is still the case, we are open for a motion.
And I can serve, but I don't need to serve as vice chair. So if anybody else wants to, but I'm happy to do whatever.
I make a motion to accept it as is.
Yeah, you were recommended by Carl, so.
Yeah.
Okay.
Vote on that?
I got a motion and a second from those two.
Okay, sure.
So I'll call the roll.
Take it.
Commissioner Zilich,
Yes.
Commissioner Jensen,
Yes.
Commissioner Sheard,
Yes.
Commissioner Rossi,
Yep.
Commissioner Tao. Yes. And Chair Jenkins. Motion passes unanimously. Thank you.
Congratulations.
Oh, thank you. I just need to practice getting more like
Vice chair.
Wyatt.
Do we have any commissioner reports?
I just want to hand out, is that what you meant by commissioners? Us?
Yes, yes, yes.
Okay, here.
Do you want to do planning or do you want to do historical advisory?
Historical advisory, you can get that, you take it and get it down to them. Of the tours that are coming up for the winners of our Historic Preservation Awards. So we have the Swain Home Tours and the Hecker Home, and it's going to be on a Saturday. And all the details are in here. 3 o'clock, we'll have tours at one house, and we'll have tours like last time that we did this, we got a lot of people, so it was really exciting. There's no charge, but the owners will be giving the tours and talking about all the work that they did in the history of the home. And I wanted Sean Weber to come and Dave Pittman. Sean can't attend because he's out of town, but Dave Pittman will be there to give him congratulations. So I just want you all to know so that hopefully you can come and tour the building on
That would
Saturday.
be Saturday,
You're out of town.
October 5th.
Saturday, October 5th, yes. 3 o'clock and 5 o'clock. And then our great sponsors. And then my personal dream would be that next year we pick a few more homes and then we actually have all the homes on tour each time we do it. So it almost becomes like a big city historic tour, like open house. And the homes are open and people can go through them. So that's kind of something I would love to see happen.
Thank you. Do we have anybody go to any meetings? Nothing? Staff reports?
We do have our Public Works Director, Fred Mayo, here. He wanted to address the commission.
Already got it.
It's on.
Good evening, everybody. Commission. I just wanted to come up.
I got it.
No, okay.
Oh, I thought the light was off. Sorry about that. Just wanted to give a quick update that we're going to be doing a overlay asphalt project on Montgomery and Myers. That's going to be starting right at the end of October. So new striping and new overlay seal.
I thought it did
sealant.
start.
No.
Okay, that scared me.
What you're seeing right now is city public works staff going out and applying some mastic that needs to be down at least about 30 days before this the sealing project comes in to kind of build up parts of the alligatoring and some of the potholes. So when they come through and do their sealing or slurry over the top, it actually gives it a better finish.
Awesome.
Okay, and that's when we're going to be looking at doing some of the striping concepts that we talked about on
Oh,
Montgomery,
good.
and we're going to be going down Myers as well. So that's pretty exciting stuff. That's one of the
Wow.
reasons why I'm here. But the other one is I've been getting questions from some of the commissioners asking about what's going on with the striping up on Orange. It's a little crooked. I'm fully aware of that. There's a couple reasons why that is. It's some of our equipment isn't really the best suited for what we're trying to do with it. And it's also the surface of the roadway. Our equipment is actually literally following the surface of the roadway. There's not a whole lot we can actually do with it other than what we have done. I know some of the bot dots on Washington Avenue and other places, we had some failures on it where traffic hit it. They actually turned them about 45 degrees. I believe we replaced most of those. There's nobody in this room more than me that bugs me with the crooked striping, but we're at the mercy of the roadway on this. We're just trying to get some fog lines down and some other striping. So at some point, this part of the section of the roadway, Orange in particularly, will be getting addressed. It's we're formulating the CIP projects for roads now. So
Yeah, I want to make sure that when we're restriping Montgomery, like we're about to do, that we're not going to have the
Can
same
that be
issues.
straight?
and
Yes.
have it
No, we're gonna make it crooked, too, because
have
it's gonna be an
have
illusion
it
for
looking
us.
like that. And I had a bunch of horror things going through my mind when I was seeing that. So.
Agreed. So there's a couple different materials too that we should probably discuss too. So what the city crews are putting down is literally paint. It's roadway marking paint. When we're doing our markings down Montgomery after a nice smooth surface, which is a major difference between up at Orange, for example, they're using thermoplastic. It's a much higher quality, better material. Paint doesn't last very long. We did all of our school crosswalks last year, all the legends that are in yellow. We did them last year. We had to do them again. Paint is very, it's a short-term product. So yes, the lines will be straight where they're supposed to be, and they'll be crooked where they're supposed to be, and they'll be thermoplastic. So
And
I just
then-
wanted to kind of bring that to everybody's attention because I've been getting emails from folks all over the place, and I just wanted to kind of address everybody at the same time. We're not hiding from it. We're aware of it, but again, we're at the mercy of the surface of the roadway.
So I drive Orange all the time when I head home. I live up that direction. And I just want to say that they might be a little crooked, but I totally appreciate the fact that they're there.
Absolutely.
Because I think it looks great. It makes it way safer. People have slowed
does.
down. They're not cutting the corners as much because I used to go up that hill and they'd be coming across because there was no stripe. There'd be people coming across there, and now they're not. They're not driving into my lane. So I think it's made a great difference. A little crooked or not, I think it's a fantastic upgrade.
I appreciate that. And I want to make sure that the message is also that our public works staff, especially on the streets department, they have been doing a lot of work this summer. And to be quite frank with you, I think it's probably the most work that we've done in the summertime in the last several years. We've done a lot, and they're working currently at night right now in preparation for Myers and Montgomery. So, and I agree, a little crooked fog line is way better than a no fog line. So, anyways, I felt compelled to address the commission with that. And if you guys have any questions, feel free to.
Yeah,
Don't
what's
make me.
the striping that you're going to do on Montgomery?
Well, we're going to be doing the thermoplastic for.
But I mean, what are the lines? Are they like where, so the parking is designated from the driving? Are you doing that
If I'm not
line?
mistaken, I have to look at the final plans because I haven't looked at them
Okay.
because
I
I
know
know
we talked about it.
there's some conceptual bump outs at the crosswalks
Yes.
and those type of things. I believe
we're
those are
gonna-
part of the package. I should have had my homework dialed a little bit more before I
Wonderful.
came in, but I do believe that was part of the. Yes,
Traffic ways.
Great.
yes, and those are all paint.
Narrow
Slow the people down.
Create much more visibility.
The traffic lane itself width is not changing. It's just on the shoulder, so it gives more of an illusion for folks
Yes.
to slow down. So,
Awesome, thank you.
okay. Any other questions that I can help
No, I'm just
answer?
glad you told us. I had people complaining to me. They thought what you had already done was, this is it. This is what's happening to the roads. So I'm really glad that you told me.
This is a new material that we're using too. We
Okay.
actually purchased this material for the first time back in July, maybe August, and we've been applying it ever since. So it's in a sense a little bit of a pilot program. It's held up where we put it at in the middle of the summer. It's held up very well in the summertime. I'm curious to see how it does after the cold weather and the moisture moves in, and if it holds up, we got a really great product. So feel very confident and hoping to see how it goes. So I'm hopeful that it's going to be really nice. So again, we were just doing some pre-work before the actual resurfacing came in. So save the city some money, and it gives our guys a chance to get out there and do some stuff for us too.
Yeah, if I could make one more request as we're looking at doing this in the future, there's a spot at Orange Avenue right before the traffic light and the merge with Orodam where the lanes kind of shift around a little bit. And it doesn't seem like it's necessary for the width of the roadway. We might want to kind of straighten those out and make them a little more logical next time we restripe. So
Thank you for that. There is a more of a holistic look and approach that we're looking at for that general area, because not a fan of the intersection, Keisha. Just for the maintenance side of it, for our signal maintainer, it's a lot of work. It's a lot of work. From what I understand, there was a roundabout design there several years ago, but
it would have been nice.
we're looking into it. Yeah. We're looking into different alternatives and looking at that area in general. So, okay. Sure. Anything else I can answer for you folks? All right, thanks. Have a great night.
I'd like to just announce that we have the last Civic Pride, or Civic 101 episode coming up on the 10th. So it's our department. It's community development. So if you want to learn all about community development, come on out. Yeah, they've been getting light.
So that's a Thursday at 6? Is that
Thursday at 6.
Thursday at 6, the 10th, October 10th?
Wait, is it the 10th? It's the 10th, right?
It's the 10th, yes.
Yep.
I have a couple of quick items as well. The Development Review Committee meets also on the 10th at 3:30. I'm not aware of what projects are on that list at this point. I don't know, Christina, if there are any at this point. There is?
Are you on that?
Well, go ahead.
So
Are you on
the Feather
No.
River
You're not? Okay.
Parks, Recreation and Parks District has requested to put some outside storage near the convention center, and that will be going through the DRC. It'll be a two-part hearing. The first will be to present it to the development review and see if that's acceptable, and then it will be a public hearing through the zoning administrator to either approve or deny the use permit
So how does that work?
for outside storage for the Parks and Recreation District.
So temporary buildings you're talking about?
They are proposing to install a Connex on the west side of the convention center, and then surround it with native landscaping to camouflage it a bit.
I know. So when you say it goes to the DRC and then it goes to the zoning administrator, what does that mean? We would get a notice?
So it was publicly noticed in the newspaper, and surrounding properties it went out to. It is considered a minor use because it would be exempt from CEQA, and minor uses can have a public hearing at a zoning administrator instead of a planning commission. However, we do have it can be bumped up to the planning commission if that would.
I don't think we want temporary, those temporary trailers. I think we have way too many of them in historic downtown.
Yeah,
personally, already.
Yeah, as
It
a
really
member of the
doesn't.
DRC, I wouldn't. I'm
I'd
not
like
going
to
accept that.
see the standard stay
So
higher.
would you prefer that this public hearing be presented before you instead of the zoning administrator?
I would.
Okay.
I just think residents find out afterwards. They see the trailers and they're like, what happened? This is not what we agreed to in historic downtown and not what we think we're.
Well, just to be clear, I think it'll actually be an improvement because they're going to put potted trees in front of it and behind it. So there's that big voided space where the big wall of the convention center on that east side or the west facing side, that will all be then covered up by.
That's what faces the river?
They're going to be on both sides of the Connex boxes. So they'll be on the front side. So when you look at it from the downtown, you'll see trees rather than seeing the void that's there right now, or seeing the Connex boxes. So that's the intention.
It sounds like habitat.
Habitat?
Hot trees for people to hide in.
There you go.
When it comes to Connex boxes, personally, I like it when they put shells around them. I mean, you can have the Connex box, but you can put a wood shell around it and make it look like something that's not a Connex box.
Yeah.
There's a lot of facades, and they're not really expensive.
Right.
And you can hide the fact that it's just a Connex box.
And you're still save money.
Yeah, Connex boxes remind me of construction sites.
Yes,
I mean,
exactly.
or
Not for
in the
a
back
store
of a stadium
downtown.
or something like that, you know, for extra seating and chairs. But
I
as far as
agree.
in the public view, I'm under the impression I like a facade of some kind around
Yeah.
it. It's a T111 siding and some trim. I mean, something.
No, some horizontal siding with.
Yeah, okay,
eave
that's fine too.
overhangs
I'm just
and-
saying, anything.
So I have two other quick items. We have the oak tree mitigation ordinance, which finally passed the city council on September 15th, so that will become law. And then we have a large project that we've been mentioned before, the luxury RV park proposed at Nelson and 70. That will be coming to the Planning Commission on its November meeting. There will be a mitigated negative declaration that will be posted for 30 days on that project before that. That's it.
And then I would like to have one staff report, and that is that I'd like to welcome our new engineer, Mr. Tim, I hope I'm not mispronouncing this, Kaber. He's been here for 18 days, and we are enjoying him. He's very knowledgeable, and we are very glad that he's part of our staff and is helping us out with some of these things, especially like subdivisions.
Welcome.
Thank you, welcome. Does that wrap it up?
And that wraps it up.
We will adjourn to October 24th, 2024 at 6 p.m.